Hi, this is Keith Davidson at Albertson & Davidson, and today I'm talking about mediation. And in particular, I want to talk to you a little bit about how do you act in mediation. What are the steps you're going to use to try and successfully navigate your mediation so that hopefully you can get a settlement that is in your favor and you can wrap up your case and be done with it. And the first step is you have to understand what your negotiation plan is. You have to have some sort of a plan or a strategy that you're going to use once you get to the mediation. For example, a common plan is setting a high anchor point. So you go out with your first offer and you want it to be a high offer, but not too high that it's laughable, but high enough to set an anchor point so that you know where you're starting from, and hopefully you're helping the other side see that they need to come up a little bit on whatever their opening bid is so that you can hopefully reach a common ground where you can settle. So the first point is, what is going to be your negotiation strategy? Everybody's a little different and has different strategies on how they do it. The second part is combining all the different items and terms that you want. And so there's a lot of times in trust and will cases where there's all sorts of little side issues, there's all sorts of little pieces of property or personal items that people care about. And so you want to think about, what are the terms that I want to propose to the other side? So something like, if you give me these 3 things, I'll give you these 3 or 4 things, and we can start going back and forth about what we really care about. And so if there's something like a stamp collection or a coin collection that I don't care about, I can put that on the list as something that I'm willing to concede to them, the other side, if they're willing to give me something in return, and that then starts the negotiation down so you can figure out what it is I care about and what it is the other side cares about. The third thing about mediation is you never want to let them see you sweat. So don't ever get up and leave a mediation unless it's a very extreme circumstance. So a lot of times people get frustrated because mediations take usually all day. It's a process. It takes time. And people get very frustrated with that. Even other lawyers, they want it to happen quickly, but it just doesn't happen quickly. It never happens quickly. So just get that out of your head. One of the things you're going to accomplish at mediation is you're either going to settle or you're going to find out some good information about what the other side really cares about in their case. And that's valuable information to have. So whether you settle or not, mediations have value. They have value to you, they have value to your case, but they only get that value if you hang in there. You can't get up and leave before the other side does, because otherwise you won't know what their breaking point is, but they'll know what your breaking point is. The final thought I'll leave you with for mediations is you need to be brutally honest about whether your case needs to settle or not. So some cases, they just have to settle. Maybe you don't have enough money to continue prosecuting the case. Maybe you don't have good facts. Maybe you have a lot of bad facts that have come out that you didn't know about before. For any number of reasons, there's some cases that just cannot continue to go forward. They must be settled. And if that's where you're at, if that's your case, just be brutally honest about it and understand that if you're in a position where you must settle your case, then you're going to have to take the best offer you can get and be done with it. You can't get everything you want. Conversely, if your case doesn't have to settle, if you have the ability to keep moving it forward because you have good evidence, you have the money to keep prosecuting it, you're willing to take the risks that are involved in taking the case to the trial, that's not a problem for you, then you can just negotiate, try to get the best offer, but if you don't like it, you can just leave and not settle. And so you have to understand what position you're in when you're in mediation. Don't make the mistake of thinking that you don't need to settle when you do, or that you do need to settle when you don't, because it really is a different ballgame in terms of the type of offer that you're going to make and the type of offer you're going to accept, depending on what your needs are to settle that case.